Good morning, friends. Today I'm going to talk about the contract law and other aspects which we haven't covered in the last lecture. So, the ninth lecture was on breach, and the previous lecture was on the introductory issues of contract law or contract per se in the economic understanding. So, this lecture is largely on the other aspects which we haven't actually dealt into the default rule as well as in the expectation damage case which we have already discussed. So the question we would start asking is the uh, question, that is, when should voluntary trade not be allowed? So the example which we have seen, that is from the law or property law, that is going back to the property law, we know that according to the cost theorem, to get efficient outcome, we should let people trade whenever they want to. That means you have to actually make a point that people are going to have their own trades. So, but also so some exception, that is some trade that ain't and shouldn't be allowed. For example, we've already seen the example of cocaine as well as uranium cases in the earlier lectures, and selling enriched uranium to a terrorist. So, I mean, if you go for trade laws, pure trade law, then trade law never outlaw whether you are selling it to an extremist or a terrorist or anybody else or a government agency. So that is the kind of understanding which is we go with a pure understanding of trade. But that is not the case when we talk about the illegal premise or under the legal premise. Similarly, with contract law, first day to get efficient outcome, enforce any contract both parties want to enforce. So this is the case we had already talked about. So enforcing a contract is also an interest of the party in that sense. But in next we will see exceptions, that is contract which should not be enforced due to externality or market failure. So these are the two problems we are going to encounter, that is uh, the enforcement of the contract based on the party's interest, as well as the exceptions of the contract which should not be enforced. So now what we can actually start with is an example of an unforeseeable contract, a contract which breaks the law. Okay, so let's begin with this example. So obviously, under this particular structure, contract to buy a kilo of cocaine is unforeseeable. All right, and less obvious is otherwise legal contract whose real purpose is circumvent the law. So the legal doctrine we deal under, the legal doctrine deals this kind of issue is derogation of public policy. That is, derogate means a detract from curtail application of a law, which is what is called the derogate, and applies to contract which could only be performed by breaking law. So if you want to actually have this trade, then you have to actually break the law. So this is what is then deals under this particular clause, or we call the derogation of public policy. But also to innocent contract whose purpose is to get around a law or regulation. So this is also a problem which we need to understand. For one example of an immutable rule, a contract to do something illegal is not enforceable. So this is another point which we have to keep in mind. So you cannot have a contract to do something illegal. So this is then that cannot be enforceable also. So there are also less obvious situation where a contract to do something perfectly legal on its face is not enforceable because the actual purpose of the contract was to circumvent the law. So as we have seen earlier, the legal doctrine here is derogation of public policy in a nutshell. So this is what is we so the derogation of public power is what is going to be talked about. That is a derogation of public policy in that sense. So, for example, labor union requires by law to negotiate in good faith. All right. So, for example, in the recent the NBA labor trouble, which has occurred not very recent in 2000s, late 2000s, so there was a dispute. That is the old CBA rule: 57% of the basketball-related income went to player salary. Now, owners were offered less than 50%, players demanding 53%. This is the dispute's basic point. And imagine the following contract. For the next 50 years, if an NBA PA accepts a CBA playing less than 55% of BRI in player's salary, then we also agree that all non-retired players will work for you as coal miners every off season at federal minimum wage. So this is a purpose is purely to bind hands in negotiations with ownership. So this is a kind of thing which normally we enter into 5 years, 6 years, 10 years. Normally people enter into contract, and then in the contract they feel happy. But contract would not be enforced in that case. So because of many reasons, that is, in general, a contract is not enforceable if it cannot be performed without breaking the law. Exceptions: if a promise is new and promise it didn't, then comes under an exception rule. I am married. My girlfriend, in for example, this case is a very interesting one to note. I am married. My girlfriend is in California, doesn't know. I promise her I'll marry her. She quits her job and moves to Madison. Then my company agrees to supply a product that we can't produce without violating a safety or environmental regulation. Then is it enforced? By keeping either promise would require breaking the law in that context. So, but I would still be liable for damage for breach. Now, in that kind of a situation, like in Ayers and Gardner case, default rule penalizes a better informed party for withholding information. Okay, so this is one way of understanding the enforcement or enforceability of contract law. And in that context, if you have a default rule versus regulation comes in, then we have to see what is the difference which it can make. So talked earlier about the default rules as the rule which is actually, if there is a gap in the contract, then this has been dealt under the default rule. So default rule apply if no other rule is specific in a nutshell. Okay, so but it can be contracted around. So again, it opens a new possibility that okay, once it is not being specified, then you can actually contract around it. So rules like derogation of public policy cannot be contracted around. This is what we have to keep in mind. That is, the policy which is breaks the law cannot be dealt under this particular clause. That is, rules of derogation of public policy cannot be contracted around. Parties to a contract can't say, even though this type of contract would normally not be valid. This one is. Okay, so rules which always applies, immutable rules or mandatory rules or regulation. These are the three things which you have in that context place. So fifth purpose of contract law is to minimize transaction cost of negotiation contracts by supplying efficient default rule and regulation. So they are trying to introduce a new thing which is called the regulation in picture. So next I want to discuss a number of ways to get out of contract, that is condition under which a contract will not be enforced. So we have already seen that when and where contract being enforced. Now let us not go to the details of it, and let's talk about when you cannot perform it. So formation, defense, and performance excuses to two contexts where this is immediately applied. So let's talk about the formation defense. The formation defense claims that a valid contract does not exist. Example, no consideration is involved. We remember the three examples which we discussed in the earlier lectures. So again, in the first two examples, there is no consideration involved. That is the uncle's promise as well as the second one, Cadillac versus the Chevy problem. So in the second performance excuse, we have a valid contract was created, but circumstances have changed and should be allowed to do not perform without penalty. So this is what is called performance excuses. So most doctrines for invalidating A contract can be explained as either individual agreed to the contract were not rational, or transaction cost or market failure is the results. So if that is the two contexts, then you have actually reconsider, or the enforcement may not be advisable. So one formation defense, that is incompetence. In the context of formation defense, if we discuss, this is one of the first and foremost thing comes in our mind, that is incompetency. What is this incompetency? Court will not enforce contract with people who can't be presumed to be rational, for example children, legally insane, etc. But again, there is an example which we are going to discuss, which is an interesting. A boy of 7 try to buy fighter jet on eBay for 130K. So this is a Fox News cutting, so it's an old one. So in this case, an over-enthusiastic 7-year-old London boy almost bought his very own real-life Harrier fighter jet on eBay, okay, of some 69,999 pound. So the British built Harrier jump jet was for sale on the site, but for a fixed price instead of an auction. So see the updated listing. So a youngster hit the buy it now and button to purchase the restored fighter jet, causing his father to quickly apologize to the seller and tell them his son was not able to buy the aircraft out of the pocket of money. So his dad rang up and profusely apologized to us. So it's still for sale. We have put it on as an auction now so that won't happen again, said a spokeswoman for Jet Art Aviation of Bradford, Central England, which is selling the Harrier. So it turns out the attention generated by the boy bid has led to a lot of interest in this jet by many others. So the auction has since received a considerable interest within the bid rolling. Chris Wilson of Jet Art Aviation Limited said in an email Wednesday, "We have currently had over 80 bids from 59 different bidders." Wilson said in a way, the 7-year-old did us a big favor, with the relisted jet having received over 120,000 hits since Friday and generating considerable more interest than we expect. So this is an example which has been there in the internet for a while. So this is in 2011 case. So what is actually the validity of this selling? So is it possible to buy, or is it a valid contract even if you perform it? So these are the things which comes under this rational presumed rationality of the buyer, which is actually in this case child. So legally insane cases also is very important, and we know that kind of cases in our day-to-day exercise, life exercise or whatever. So the second point is actually incompetency. One party was not competent to enter into the agreement, so no meeting of mind takes place in that. Of course, courts won't enforce a contract signed by someone who wasn't competent. So these are the things which is actually comes under the formation defense case. So what if you signed a contract while drunk? So there is another set of question immediately drives. That is, drinking makes people's mind or incompetent. So this is a question which is therefore very seriously we need to understand. What if you sign a contract while drunk? So you need to have been really, really, really drunk to get out of contract. So intoxicated to the extent of being unable to comprehend the nature and consequence of the instrument he executed. So this is why people uh, are very careful while driving. So in Malayalam there is a movie called Pavada. Okay, there you see this problem, that is whether the person that one character signs his thing. So it is also a consent which was forged in the bar. So is it enforceable? So there is a lot of issue. So it is actually under thing. Then they found out that it was being cheated. So similarly, but prima facie in that case, it is enforceable. This is what we have seen in the movie. So Lucifer versus Zemmer, Virginia Supreme Court case of 1954 is a classic case of this kind. So Samer and his wife owned a farm, the Ferguson farm. Lucy had been trying to buy it for some time. So while out to drink, Lucy offers $50,000. Samer responded, "You don't have $50,000. So we hereby agree to sell to wife of Lucy, whoever Lucy, the Ferguson farm complete for $50,000. Title satisfactory to buy it." So this is an old Virginia restaurant bill they were written. And that is what this is written in that bill. So is it a valid contract? This is what is. So you can be pretty drunk and still be bound by the contract you signed. So in this case, it is very clear that it is actually bound. So might think meeting of minds would be impossible, but imagine what would happen if the rule went the other way. Borat lawsuits, for example, Julie Hilden, Borat's sequel, legal proceedings against not Kazakh journalist for Mike Benefit Guidelines American in film. So moral that lawsuits is actually a case which we need to be very careful. In the Lucy versus Sehmer case, finally the court said that you are liable. You have to sell the land to Lucy or the Ferguson farm to Lucy. So moral of the story is don't get drunk with the people who might ask you to sign a contract. So that is the only thing you can refrain from. So next we study another formation difference which is called the dare constraint. So given that lesson, please be very careful while dealing with people like that. So let us talk about dare constraint. What is dare constraint? So dire constraint is actually a situation where you are in a dire need. So you make actually a sort of contract or you enter into negotiation or whatever because of the situation. So one situation is what is called necessity. I am about to starve. Someone offers me a sandwich of for rupees $10,000. So if you are in the verge of starvation or in the verge of death due to starvation, so you will accept it. So my boat, and another example is my boat is about to sink. Someone offers me a ride to a shore for $1,000,000. So these are called necessities. So contract would not be upheld in that case. I signed it out of necessity. So this is very important clause which people deal with under the contract. So the second kind of dire constraint is duress. That is, other party is responsible for situation I am in. So this is what is, I made him an offer he couldn't refuse. So this is a standard argument people normally applies in day to day. This is what is called duress. So you force the person to do it, but it is not out of, then it is not a contract. It is not enforceable. So contract signed at gunpoint would not be legally enforceable. Okay. So these are the things which is actually comes under the dare constraint thing. Now there is a very different point which is an economic point which David Friedman asked in his or discussed in his book. He was talking about the duress, okay, which we said that out of gunpoint and all, it is not enforceable. So example here is actually a mugger threatens to kill you unless you give him $100. Okay, you write him a check. Do you have to honor the check? Okay. Efficiency requires enforcing a contract if both parties want it to be enforced. So this is under this efficiency rule. If you apply, this is possible. That is, efficiency requires enforcing a contract if both parties wanted it to be enforceable. That is, you had given him $100 because your life is more valued. So he want your $100. So you'd rather pay 100 than be killed. Then is it binding? So why not enforce it? So make smugglers more profitable in that context. So why we are not doing it? Not because it is it will create a social suboptimality. So mugging more profitable and leads to more mugging. So it gives incentive. It is destructive incentive in that sense. So there is a trade-off that is refuse to enforce a Pareto improving trade in order to avoid an incentive for a bad behavior. So this is what is actually the result why people are not doing it. This is a completely different understanding. This is an economic way of looking at it. You are disincentivizing by this, though it has been enforced because both parties wanted to enforce the same. So what about necessity? Do we have an exception in this context? Now, same logic doesn't work for necessity. So you get caught in a storm on your 1 million sailboat. Now tugboat offers to tow you to shore, but for 9 lakh. Otherwise, he will save your life, but let your boat sink. This is the kind. So you say that duress if we enforce contract incentive for more crimes. All right. So necessity if we enforce contract incentive for more tugboats to be whaled to rescue sailboats. So why is that bad? Of course it is bad because now should I motor around looking for a sailboat to save? So that is a question which so social cost is equal to private cost is equal to value of any time or my time. So social benefit is equal to profitability times value of boat minus cost of tow. Now private benefit is equal to probability times price I can charge minus cost of tow. So if tugboat captain can charge the whole value of the boat, he spend efficient amount of time saving sailboats. So maybe we should enforce this contract. So should I sail today? So this is a question immediately comes in by from the sailboat side. Suppose a tugboat is there to rescue me if there is a storm. So social benefit is equal to private benefit, which is equal to how much I enjoy sailing. So social cost is equal to probability times cost of tow. Now private cost is equal to probability times price he can charge. So if tugboat captain can only charge cost of tow, I sail efficient amount. So if he can charge the whole value of the boat, I undersail. So this is the kind of situation. So this is about the incident about the necessity vis-a-vis the duress. So same transaction sets incentive on both parties, price that would be efficient for one decision is inefficient for other. So this is what is the point frequent try to make. So put the incentive where it would do the most good. So now what we have to do is actually let us have a law or a kind of proposition where it gives more value. So least inefficient price is somewhere in the middle and probably not the price that would be negotiated in the middle of the storm. So this is what is actually normally some has to keep in mind. So makes sense for court to overturn contracts signed under necessity, replace them with ex ante optimal terms. So more general point is a single price creates multiple incentive, may be impossible to get efficient behavior on all dimensions. So now the question is a real duress versus fake duress. Now is duress or out of dare constraint vis-a-vis the dare constraint which is faked. Okay. So court won't enforce contract signed under threat of harm. So give me $100 or I'll shoot you. Now, this is a case, but many negotiations contain threat. Give me a rise or I'll quit. This is also a threat. So give me $100, I'll shoot you. One example. Give me a rise or I'll quit. Second example. So both are actually threat. So how far you can go for? What is the extent, or how far it is, or what would be the extent which we can accept as a threat? So this is a question anyone can ask. So $300, or sorry, $3,000 is my final offer for the car. Take it or I walk. So this is also a threat. What is the difference between all these things? So the difference is the threat of destruction of value versus failure to create value. So this is, so one is actually a destruction of value. So court or economist would always try to keep in this fact, that whether your threat is actually a value creating or value destructive. Okay. So I promise, a promise is enforceable if extracted as price of cooperating in creating value, not if it was extracted by threat to destroy value. So the first one is destroy value. Okay, but not in the second and third. This is a case which we can see from different standard books as well as references, like the Alaska Packers Association versus Domenico, U.S. Circuit Appeal to 1902. What is this case? Captain hires crew in Seattle for fishing expedition to Alaska. In Alaska, while they reached, a crew demanded higher wage or they quit. Then captain agrees. Back in Seattle, captain refused to pay the higher wages, claiming he agreed to them under duress. So this is the case. Court ruled for captain. Okay. So this is the duress example. Since crew had already agreed to do the work, no new consideration was given for promise of higher wage. That is what is the logic of it. So the next issue we need to talk for voiding contract is impossibility. Now, when performance becomes impossible, should promisor owe damages or be excused from performance? So a perfect contract would explicitly state who bears each risk. A contract may give clues as to how gaps should be filled. So it is very important to write a contract. And now one of the highly paid profession in the world is contract lawyers. Because if you are so careful as well as sharp in making your point, judicious in making your point, then you will be paid very high, because the party will get as much benefit as they expect. So industry, for example, industry customs might be clear, but in some case court must fill gaps. So you can't, but even if you are a very good lawyer and all, but you can't make a complete contract, because completing contract is literally impossible. So in most situation, when neither contract nor industry norms offer guidance, promisor is held liable for breach. Okay. So if you don't have actually a guidance or norm offers what should be done, then it is always the promisor being liable, because we have already seen the promisor is actually the efficient bearer risk. But there are exceptions for that also. That is, a change destroyed a base assumption on which the contract was made. That is, efficiency requires assigning liability to the party that can bear the risk at the least cost. That is, how to determine who that is. So who is having the efficient bearing of risk? So it's a question again. So who is the efficient bearer of a particular risk? Friedman offers several bases of making this determination. The first point is actually spreading losses across many transactions. The other issue is moral hazard, who is in better position to influence outcome. And there is another problem, adverse selection, who is more aware of risk even if he can't do anything about it. So the party with control over some part of the production process is in a better position both to prevent loss as well as to predict them. So it follow that an efficient contract will usually assign the loss associated with something going wrong to the party with control over the particular something, whatever. So this is why I said the contract lawyer's importance. So for who is actually aware of all this contract, they may make a fortune. So that is why Hartley versus Bechendale was surprising, right? That is, Bechendale shipper could influence speed of delivery, Hartley could not, because so Bechendale was efficient bearer of the risk of delay. And court ruled he did no damage for lost profit, forcing Hartley to bear much of this risk. So only makes sense as a penalty default. Rule creates incentive for Hartley to reveal urgency of this shipment. So a contract based on faulty information, which is four doctrines for invalidating a contract. So this is another set of problem which we are going to discuss. That is, first one is a fraud, second one is failure to disclosure, third is frustration of purpose, and the final one mutual mistake. So if you have all the four or any of this thing, then the contracts are faulty. So first one is a fraud. Okay, what is a fraud? So one party was deliberately tricked, then you called it as fraud. So women, this is a case of 2011. Women buy fake wooden iPad for $180. So Spartanburg County in US. So a woman at an upstate McDonald's thought she was getting an iPad at a bargaining price, but instead she got a very expensive piece of wood. Ashley McDowell, 22, said she was getting food at about 10 p.m. Monday when two women approached her in the parking lot. The men showed McDowell a new iPad and told her that they had bought several of them in bulk at a good price and had them in their FedEx boxes in the trunk of their car. So the men offered to sell McDowell one of the iPad for $300. She told them that she only had 180 and they agreed to sell her one for that amount. The men gave McDowell a FedEx box. Once at home, she opened it and found a piece of wood painted black with an Apple logo on it. McDowell said the men were in a white Chevy Impala with no rims and untinted windows. She said one of the men had a gold tooth. So anyone with information is asked to call Crime Stoppers. So this is a case which was registered. Now this is very funny, right? So what if you trick someone by withholding information? So this is I can't actually comment. You just think this is what is called the extent of fraud. So what if you trick someone by withholding information? So this is the second problem. So under the civil law, there is a duty to disclose. If you fail to supply information, you should have contract will be void failure to disclosure. So less so under the common law, seller has to share information about hidden dangers. So but generally not information that makes a product less valuable without making dangerous. Exception is actually new products comes with implied warranty of fitness. Another exception is Opti versus Lemire. So duty to disclose under common law. Under common law, a seller requires to inform buyer about hidden safety risks, generally not other information. But Opti versus Lemire, 1960 cases, seller knew building was infested with termites, did not tell buyer, and termites should have been exterminated immediately to prevent further damage. Court in Opti imposed duty to disclose, which is awarded damage for Opti. Now some state requires used car dealers to reveal major repair done, sellers of home to reveal certain types of defects. So these are the things which is immediately comes under this thing of disclosure. So failure to disclose, That is the third problem. The Chinese man sues wife for being ugly, wins 1.2 lakh dollar. So this is a very interesting case. A man, this is also in 2012 case, a man from northern China divorced and sued his wife earlier this year for being ugly. That is not a joke. Okay. Neither is this the man that man recently won the lawsuit. That man is Jiang Feng. He said his issue with his wife's looks only began after the couple's daughter was born. Feng was appalled by the child's appearance, calling her incredibly ugly and saying she resembles neither one of us or one of the parent. So, with that being the case, Feng initially accused his wife of cheating. It was at that point that his wife, who has not been named, came forward saying she had spent $1 lakh on intense plastic surgeries to drastically change her appearance before she met Feng. She never told Feng about those surgeries. When Feng found out about the procedures, he filed the lawsuit and he said the woman convinced him to marry her under false pretense. A judge agreed, awarding Feng 1 point. That is $1,20,000. This is also an example. So if both parties were misinformed, this is the other case. That is the frustration of purpose and mutual mistake. So the frustration of purpose is something change in circumstance made the original promise pointless. Coronation case when a contingency makes performance pointless, assign liability to party who can bear risk at least cost. So in mutual mistake about fact, circumstance had already changed, but we didn't know that. Okay. So logger buys land with the timber on it, but forest fire had wiped out the timber the week before. So this is a mutual mistake about identity, that is disagreement over what was being sold, etc. So these are the kind of things which is comes under the misinformed system. That is also an exception in that sense of contract. Another principle for allocating risk efficiently is uniting knowledge and control. In that context, what we have to know is actually the case again, Hartley and Baxendale case, the Miller and Shipper case. That is uniting knowledge and control. So Hartley knew shipment was time critical, but Baxendale was deciding how to ship crankshaft, boat or train. Party that had information was not the party making decision in that context. So efficiency generally requires uniting knowledge and control. Contracts that unite knowledge and control are generally efficient should be upheld. So the contract that separates knowledge and control may be inefficient should more often be set aside. So this is the kind of thing which people try to argue for. So whereas the mutual versus unilateral mistake is different. That is mutual mistake. Neither party had correct information. Contract neither united nor separated knowledge and control. Unilateral mistake is one party has mistaken information. I know your car is a valuable antique. You think it's worthless piece. So you sell it to me at a low price. So contract based on unilateral mistakes are generally upheld. Contract based on unilateral mistake generally unite knowledge and control. And enforcing them creates an incentive to gather information. So unilateral mistake in the case of Lane Law versus Oregon, US Supreme Court 1815 case. So this is a very interesting case, that is unilateral mistake. War of 1812 British blockade port of New Orleans. The price of tobacco fell since it couldn't be exported. So Oregon, that is a tobacco buyer, learned that the war was over. Immediately negotiated with the Lane Law firm to buy a bunch of tobacco at the depressed wartime price. So next day, the news broke the war had ended. Price of tobacco went up. Lane Law sued. Supreme Court ruled that Oregon was not required to communicate his information. So in that context also, this is a very important step to understand that what can be actually asked and what cannot be asked. or what can be disclosed, what cannot be disclosed. Based on that, what contract being enforced and what cannot be enforced. So these are the problems which is comes as exception as well as enforcement issues of contract. And with this, I would stop today's lecture. Thank you for listening. Thank you very much.